I'd just like to go back to the unfair dismissal issues. Where does workplace bullying come into it? Because what an employer might say, oh no, I didn't, push them out of their employment, but yet the employee might feel that way just based on the behaviour of their employer towards them.
Sure, if I can just start off. Just interestingly, there's a relatively new development in the Fair Work Commission jurisdiction called the bullying jurisdiction. So, excuse me, but it only applies to a current employee. So that if they've been terminated, they can't really do it. But what they can do is seek an order from the Commission to stop the bullying. They don't get compensation. It's an application, and the Commission has to deal with the matter within 14 days. And that if they're successful in that application, the Commission can actually make an order to stop the bullying and can be really flexible in the orders that it can make in relation to bullying.
It's interesting you meant that it's really related to current employees.
Yeah.
So in a way it forces you to be in employment and go and seek redress rather than resign. If you resigned, there's no...
That's correct, because it's an order to stop the bullying. So obviously after you've left the employment, then it doesn't apply anymore. And that's always a tricky situation for an employee, is that they're still working there, they still want to maintain that relationship with the employer, and yet they're making a quasi-legal application to a tribunal for an order.
What are some of the orders that might be made? Can you give an example?
Yeah, there's been some real flexibility in that. For example, I was reading a case the other day where the person who was alleged to have done the bullying wasn't allowed to, and this is real, wasn't allowed to exercise in front of this other female co-worker. So he was I think he was a bodybuilder or a fitness person.
I see. Interesting.
And interesting in relation to the times as well, in that he could exercise at the workplace after or before a certain time, but not at other times. So they can be really, really flexible in relation to how they stop the bullying.
It depends on each circumstance.
Yeah. And it's really about, perhaps about minimising the contact between the perpetrator and the person who's been allegedly bullied, so that they can continue to work at the workplace, but then they don't, those issues don't flare up again.
And what about, we've touched a bit on bullying, but what about, where does discrimination come into unfair dismissal? Rebekah?
So obviously unfair dismissal isn't the only type of dismissal application that Fair Work initially can hear. Applications for adverse action or general protections are also called, can also be made to the Fair Work Commission at first instance if they involve a dismissal. And they generally, those applications relate to if an employee feels they've been adversely treated because of a discriminatory type attribute. So things like race, sex, disability, things like that. They also, similar types of applications can also be made under anti-discrimination legislation.
So what kind of orders can a court make in an unfair dismissal case? Can they order that the employer re-employ that person?
So the primary remedy for unfair dismissal is actually reinstatement under the legislation. The most common is actually compensation, though in order to receive compensation, an employer or an employee needs to demonstrate that the relationship is no longer tenable, or there's a serious breakdown in that particular relationship. There's a reason why reinstatement wouldn't be suitable.
Right. Rebekah, how is compensation calculated?
Compensation for unfair dismissal is basically calculated by reference to financial loss. Right. So if there's been a dismissal where somebody's been really badly humiliated and procedurally very unfair, that doesn't actually lead to extra compensation. So for example, it's quite a common situation where an employee has been unfairly dismissed, to make an application, and then they get a new job within, say, 6 weeks, which is a great thing. But then their financial losses will be capped at the 6 weeks level. So if they've received notice pay as well for leaving, plus some unfair some annual leave entitlements, they may have actually suffered no financial loss.
Mm-hmm. An interesting point there to note is if the reason for the dismissal being found to be unfair is a procedural reason, often some of the decisions, or some of the more recent decisions, have only awarded 1 or 2 weeks compensation, because ultimately if those employees had followed the proper process, the employee would have only been employed for another week or 2 because of the seriousness of the reason for their termination.
That's right. If I can just break in, because what's often happens in these situations is that the termination is a culmination of events. So a whole lot of things have gone on up to that, and so the employer has sort of on their last straw is to say, well, I've put up with it for long enough. Now I'm going to sack you. But as Rebekah said, that if they didn't sack them for that reason, they probably weren't going to last there for much longer anyway. And that's very common in that there's usually more than one reason or more than one thing that's gone on in the employment relationship leading to the termination. So it's really an uncommon situation when an employer is just, on the basis of one incident, with a good previous history, just says, no, now you're gone.
So we're coming to the end of our show. Thank you, Rebekah, Paul and Dinesh, for joining us. You were very informative. For more information, you can visit our website lawhelpaustralia.org, and you can also catch up on our previous episodes on our YouTube channel. Thank you for joining us.